Let's take a look at privacy at work. Employers gather, generate, and store a great deal of information about their employees. Applications, performance appraisals, payroll records, social security numbers, medical information, grievance filings, and disciplinary actions are among the many records that employers typically maintain. Employers also monitor employees' actions and investigate allegations of wrongdoing. The volume of information available about employees and the means of monitoring their actions have expanded greatly in recent years. All of these record-keeping and information-gathering activities raise questions of privacy. Most people are under no illusion that they are sacrificing some privacy when they go to work and are screened, supervised, evaluated, investigated, and generally watched. Legal protections for employee privacy can be found in the Constitution, common law, and statutes, though courts generally view the privacy rights of employees as minimal. The U.S. Constitution does not explicitly provide for a right to privacy. Some state constitutions do, such as California's. However, constitutionally protected privacy rights have been fashioned out of the Fourth Amendment's protection against unreasonable search or seizure. In the leading Supreme Court case on privacy rights of public employees, a public employer had placed an employee suspected of wrongdoing on administrative leave and then conducted multiple searches of his office. The court decided that public employees enjoy no constitutional protection from workplace searches, and that public employers need not establish probable cause before conducting workplace searches. Plaintiffs must first show that they had reasonable expectations of privacy under the circumstances. If this is shown, public employers must defend the reasonableness of their actions both at their inception and in their scope. Searches are reasonable at their inception when there are reasonable grounds for believing that they will produce evidence of wrongdoing or when they are necessary for non-investigatory work-related purposes like retrieving files. Searches are reasonable in scope when the measures employed are not excessive in light of the purpose of the search and the seriousness of the suspected misconduct. Public employers need not establish probable cause or obtain warrants before conducting workplace searches. However, they must be prepared to defend the reasonableness of the search and other actions that infringe on employees' reasonable expectations of privacy. The idea of reasonable expectation of privacy is a key concept in workplace privacy law. If an employee cannot be said to have a reasonable expectation of privacy under the circumstances, he or she will not prevail in a privacy claim. One factor often considered by the courts is the existence of a policy or prior notification to employees regarding the limits of their privacy right. To a great extent, if employers tell employees that they're subject to monitoring, searches, and other arguably invasive actions, those employees will not be deemed to have any reasonable expectation of privacy. Employers should establish privacy policies that alert employees to the limits of their privacy rights in the workplace. Other circumstances under which a reasonable expectation of privacy is more likely to be found include intrusions that take place in areas of the workplace that are usually regarded as private or occur outside the workplace. Intrusions that are effected through deceptive, secretive means, like hidden cameras, may also violate the right to privacy. Individuals, including employees, have a common law remedy for invasion of privacy. Most states recognize the following privacy torts: intrusion upon seclusion, public disclosure of private fact, placement in a false light, and appropriation of a name or a likeness. One fundamental way in which privacy is violated is by others snooping, prying, or otherwise engaging in unwarranted intrusions into one's private affair. To establish that privacy has been indeed invaded, in this manner, a plaintiff must show that an intentional intrusion into his or her private affairs occurred, and the nature of the intrusion was such that it would be highly offensive to a reasonable person. Also, if the intrusion is successfully repelled, there is no invasion of privacy. When an employee refused her employer's demand to turn over her private cell phone records for an investigation, the employee had no privacy claim. Another way that privacy can be violated is by taking private and sensitive information and indiscriminately bandying it about. To establish a public disclosure of private facts claim, plaintiffs must show that private facts of their lives were broadly disclosed to others in a manner that would be highly offensive to a reasonable person. Most privacy tort claims arising in the workplace are of the two preceding varieties. However, an individual's privacy can also be violated by placement in false light. In false light claims, the plaintiff must show that false information was broadly and knowingly publicized, and being placed in this false light would have been highly offensive to a reasonable person. Employees also occasionally allege privacy violations through appropriation of a name or likeness. In appropriation claims, the symbolic value of one's name or likeness, which others then use for commercial gain, is at issue. A variety of other common law tort claims are often raised in conjunction with privacy claims. Perhaps the most common of these is intentional infliction of emotional distress. Other tort claims that arise in the context of handling employee information or investigating employee conduct include defamation and malicious prosecution. Many of the records that employers maintain about their employees are incorporated into personnel files that are kept for each employee. The handling of personnel records is mainly a matter of employer privacy rather than the law. Some states have laws that give employees the right, under specified circumstances, to review and perhaps copy the contents of their personnel file. The most comprehensive law dealing with personnel records is the Federal Privacy Act. The Privacy Act regulates the handling of personnel records by agencies of the federal government. The Act defines record broadly to include any item, collection, or grouping of information about an individual that is maintained by an agency. The Privacy Act also limits the kinds of information that federal agencies can keep regarding their employees and imposes a duty on federal agencies to maintain accurate records. Violations of the Privacy Act can be difficult to prove because plaintiffs must show the violations were intentional or willful and there were actual damages such as an adverse employment determination. The Privacy Act does not apply to private sector employers. However, if an employer operates in a state with a personnel records law, the employer generally has to allow employees to access their personnel file. In terms of divulging information, communication of false, damaging information to third parties without a legitimate need to know might lead to defamation claims. Even information that is true could prompt a legal claim for public disclosure of private facts if the information is genuinely private in nature and effectively made public knowledge. It is advisable for private sector employers to obtain the consent of employees prior to divulging information from their personnel records to third parties. Employers, even those that do not self-insure or administer their own health plans, amass a considerable amount of medical information on their employees. The Americans with Disability Act places limits on the type of medical information that can be obtained from employees. After employment begins, medical information can be gathered only to the extent that is job-related and necessary. The ADA requires employers to keep information obtained on an employee medical exam or inquiry in a location apart from other personnel records and treat it as confidential medical information. The OSHA provides employees and unions with the right to access medical and exposure records created in compliance with the Act. A number of Occupational Safety and Health Administration standards require medical monitoring of individual employees, as well as monitoring of the workplace for levels of exposure to toxic substance and harmful physical agents. Because occupational diseases can take a long time to develop, exposure records must be maintained for 30 years, and medical records for the duration of employment plus 30 years. Medical records of short-term employees, less than 1 year, need not be retained as long as they are provided to those employees upon termination of employment. Unions and health professionals need the specific written consent of employees to have access to their personal medical records, but they can examine exposure records without obtaining consent. Medical privacy regulations under the Health Insurance Portability and Accountability (HIPAA) are also relevant. These regulations primarily affect healthcare providers, and self-insured companies. However, any employer that receives protected health information from insurers or healthcare providers has obligation under the law. Parties with access to protected health information must limit the uses and disclosure of that information, train staff on maintaining the privacy of medical information, and notify employees of their rights. Employers have the right to inspect and copy their medical records and propose corrections. However, the regulations do not require that consent be obtained before using or disclosing information in employees' medical records. Additionally, HIPAA regulations apply only to medical information derived from the administration of group health plans. Other sources of medical information are not affected. The HIPAA medical privacy regulations further underscore the need to handle medical information in an especially careful, confidential manner. With video surveillance becoming increasingly common in everyday life, employers use video cameras to keep tabs on both customers and employees. In general, employers can turn video cameras on their employees without significant legal concern. The Fourth Amendment claim of an employee of a public university who was videotaped stealing money from the university box office failed. Even though the video camera was hidden and she was not warned that she was being subject to video surveillance, the court concluded that her constitutional rights had not been violated. In reaching the conclusion that she had no reasonable expectation of privacy, the court relied heavily on the facts that her work area was open to view by both coworkers and the public, and her job involved the handling of money. However, although informing employees that they are subject to surveillance is clearly not necessary in all cases, employers are on surer ground if they inform employees that they are subject to monitoring and surveillance. Employers must not conduct surveillance of employees engaged in protected concerted activities, including union organizing. Video surveillance that occurs off the job is more likely to break privacy law than is surveillance performed in the workplace. Many of these cases involve employers enlisting investigators to determine whether employees claiming workers' compensation or disability benefits are really unable to work. Surveillance of employees outside the workplace, if it occurs at all, must be limited to public area. Computers and other electronic information processing and communication devices are ubiquitous in the workplace and elsewhere. Most employees spend a good part of their workday, and often their non-work time as well, tethered to electronic communications and other information processing devices. The reliance on electronic communication devices opens new avenues for the monitoring and surveillance of employees and poses profound privacy issues. The Electronic Communications Privacy Act is not exclusively an employment law, but it has been used to challenge employer intrusions of privacy of electronic communication. Under the ECPA, employers are prohibited from intentionally intercepting wire, oral, or electronic communications and from disclosing such information. The unauthorized accessing of stored electronic communications is also prohibited. The distinction between intercepting electronic communication and accessing stored communications has proved troublesome to apply to communications such as email and internet sites. Courts have generally held that the stricter penalties associated with interception apply only when a communication is obtained at the same time it was sent. There is some notable exception to the ECPA's general requirements. Interceptions are legal if prior consent to them was granted. Providers of wire or electronic communication services are exempted from the law's requirements if it's necessary to render service or to protect the rights of property. In the context of telephone conversations, employers can use additional extensions on business phones to monitor business calls for service quality or other business purposes, but cannot listen in on personal calls. State laws are sometimes more restrictive, including requiring notification to all parties that calls are subject to monitoring. Personal calls can be monitored only to the degree needed to determine if they are indeed personal. Thus, an employer violated the ECPA by intercepting, tape recording, and listening to all of its employees' personal calls. Under the Stored Communications provisions of the ECPA, only the provider of electronic communication service on which the message is stored and users of that service can authorize the accessing of stored communication. Overall, employees are well advised to not assume that their emails and other electronic communications will not be read by their employers, particularly when the employers are the providers of the communication system. The U.S. Supreme Court has been cautious about expanding its recognition of privacy in electronic communication. While criminal cases are different from cases involving public employees, judicial appreciation of the need for privacy in electronic communications seems to be growing. The importance of conducting immediate and thorough investigations of all allegations in the workplace cannot be understated. Many other situations also require investigation, including potential violations of employer policies, civil law, and criminal law. Means of investigating include searches, interrogations, and even polygraph exams. Decisions must also be made about what, if anything, to disclose regarding the outcomes of investigations and what to do if allegations of wrongdoing are substantiated. Some investigations are handled by managers or legal staff. Others involve outside counsel or private investigators. Those conducting investigations should be credible and convincing if called upon to be witnesses in legal proceedings. The Fair and Accurate Credit Transactions Act of 2003, which amended the Fair Credit Reporting Act, clarified that employers could use outside investigators for suspected employee misconduct without requiring prior consent. However, if an adverse action is taken based on that information, the employer is still required to disclose to the employee the nature and substance of the information that was provided. Investigations sometimes entail searches of work areas, desks, files, lockers, and other venues that might yield evidence of wrongdoing. Searches, by their nature, are intrusive because they delve into the contents of things that are not in plain view. Employers are generally free to conduct workplace searches, subject to the limitations imposed by the Fourth Amendment for public employees and privacy torts, particularly intrusion upon seclusion. Employers should establish policies notifying employees regarding of the circumstances under which searches will occur, communicate these policies, and enforce them by conducting searches only under the stated circumstance. The searches themselves should be conducted in a reasonable manner. Evidence obtained through searches, particularly related to potential criminal activity, must be handled carefully and kept in a secure location. Because consent is a defense to privacy claims, obtaining consent prior to conducting searches is desirable. However, employers must be careful in how they go about obtaining consent. Some searches are more problematic than others. Strip searches are highly intrusive and likely to inflict emotional distress. Except for unusual situations such as prisons, strip searches should never be conducted. Contact with employees during searches of their person should be avoided or at least minimized. To lessen the chance of sexual harassment claims, any search involving contact should be conducted by someone of the same sex. To the extent possible, searches should be conducted away from the view of public and coworkers. To avoid falsely communicating to others that an employee has done something bad, occasioning a defamation claim. Deceptive means of conducting searches in which an attempt is made to conceal the fact that the search is taking place should generally be avoided. Investigations of potential misconduct usually entail interviewing witnesses and interrogating employees accused or suspected of wrongdoing. Interrogations have enormous potential for gathering legal claims, especially false imprisonment and infliction of emotional distress. Statutes allow employers to take reasonable actions to protect their property against theft, but this does not include forcing employees to submit to interrogations or remain in the workplace against their will. Absent the need to stop the theft of employer property, employers should not attempt to detain employees suspected of wrongdoing or force them to submit to interrogations against their will. Instead, the cooperation of employees in investigations should be requested. If the employee refuses, employers have the option of disciplining or terminating the employee, or if a crime has been committed, involving the police. To minimize the chance of false imprisonment or infliction of emotional distress, make it clear to the employee that they're free to leave the interview. Do not threaten arrest. Do not lock or physically obstruct the door, and keep them as brief as possible. Employees do not have the right to have attorneys present in these situations. However, union representation must be allowed for employee investigations that may reasonably result in discipline or discharge. This is referred to as an employee's Weingarten rights, named after the case in which the Supreme Court decided that such representation must be permitted to unionized employees because it's a form of concerted activity. The presence of a union representative must be requested by employees. It need not be offered. Routine conversations are not covered, nor are situations in which a decision to administer discipline has already been made. The union's representative role is circumcised. He or she is there as an observer and not to engage in bargaining over the prospective disciplinary action. The NLRB's current view is that non-union employees do not have any right to be accompanied by coworkers when being interviewed by management for possible discipline. The board reasoned that non-union workplaces should be treated differently because coworkers do not represent the interests of the entire workforce and more likely to compromise the confidentiality of investigations. The board viewed that employers should be allowed to conduct required investigations in a thorough, sensitive, and confidential manner. The Employee Polygraph Protection Act, or EPPA, prohibits most pre-employment polygraph exams by private sector employers. However, polygraphs can be used for ongoing investigations of theft, embezzlement, sabotage, and related activities that result in economic loss or injury to an employer's business. Individuals can be asked to submit to polygraphs in connection with such investigations only if they've had access to the property involved in the investigation and the employer has reasonable suspicion of their involvement. They also must be given written information regarding the specific incident or activity being investigated and the basis for selecting particular employees for the testing. Reasonable suspicion must be based on evidence that goes beyond the mere fact of access or proximity. Even for investigatory purposes, submissions to a polygraph exam cannot be required or made a condition of employment, or refusal to submit cannot be the basis for discipline or discharge. Procedures include: employees must not be asked questions designed to degrade or needlessly intrude. Employees must not be asked questions concerning religious, racial, political, sexual, or other beliefs. Employees must be able to review all questions ahead of time. Employees must be informed about the observational or recording devices that are being used. Employees must have the right to terminate a polygraph at any time. Employees must not be tested if they have a documentation that a physical or mental condition might cause abnormal responses. Employees have the right to a written copy of any opinion or conclusion based on the test. Investigations gather information. If the wrong conclusions are drawn and communicated to others in a manner that causes qualified privilege to be lost, defamation claims are likely. To quell rumors and to demonstrate the enforcement of policy, employers often need to say something about the outcomes of investigations. The general advice is to treat such information as sensitive and limit communication to those with a legitimate need to know. Employee misconduct is sometimes criminal in nature. The evidence used by employers to reach employment decisions and the process of gathering that evidence is different from what's needed to obtain criminal conviction. Employers often choose to deal with criminal activities by terminating employees rather than seeking prosecution. The latter course of action might require court appearances by company personnel and invite unwanted publicity. Employers do not have to be correct or have ironclad evidence that employees have committed crimes to seek their prosecution, but they do have to have reasonable grounds for pursuing legal action. Deciding to terminate an employee is a weighty decision in its own right.